Good morning, and thank you for joining me on the path to liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the Fast Friday edition of the show for November 10th, 2023. And today in history, November 10th, 1798, the Kentucky General Assembly passed resolutions drafted by Thomas Jefferson in response to the hated Alien and Sedition Acts, and they are loaded with Jeffersonian principles on the structure of the Constitution. So on this episode, I've got 5 of those core principles rooted in the principles of the American Revolution, the radical change in the viewpoints of the people from 1760 or so till the shot heard round the world in 1775, plus a bonus 6th one if I have time, on what to do about usurpation of power. And let's start it out with the first one, and that is that government does not have unlimited power. That is the basis of everything. It is only authorized to do a certain amount of things, and that's how he starts out these resolutions. Resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government. And if we look to the Declaration of Independence, that list of grievances, which were really called in the Declaration itself, injuries and usurpations, this is one of them. For suspending our own legislatures and declaring themselves invested with a power to legislate for us in all cases whatsoever. And of course, if you've been following the show, you know that that's in reference to the Declaratory Act of 1766, where the King and British Parliament claimed power over the colonies in all cases whatsoever. This is unlimited power. Thomas Paine, of course, said such unlimited power can belong only to God, and that's why you had to keep fighting even when the odds were so much against them in the winter of 1776. This was the root cause of the controversy between the colonies and Great Britain, that they claimed this unlimited power over them in all cases whatsoever. So it's no surprise that Jefferson started out his Kentucky resolutions with that in the first line. So number 2 is about consent, but he ties it in here near the end with this idea of all cases whatsoever, unlimited power. And he's talking about how the resolution should be passed along to other states. He says it is our hope, basically, that they will concur with this Commonwealth in considering the said acts as so palpably against the Constitution as to amount to an undisguised declaration that the compact, that's the Constitution, is not meant to be the measure of the powers of the general government, but that will proceed in the exercise over these states of all powers whatsoever. Jefferson certainly knew what he was doing when he used that phrase, all powers whatsoever. Anyone who knew anything at the time knew this was a reference to the British claiming power over the colonies in all cases whatsoever in the Declaratory Act. And he goes on, he says that they will view this as seizing the rights of the states and consolidating them in the hands of the general government with a power assumed to bind the states, not merely in cases made federal, so those in pursuance of the Constitution, of the delegated powers of the Constitution, but in all cases whatsoever, by laws made not with their consent, but by others against their consent. So if the people of the several states consented through the ratification process just a few years, not that long before this, they consented to a constitution which created a new general government, and that general government was only authorized to exercise certain powers that were in the Constitution. That means they did not consent to the government going beyond those limits. And as soon as they go beyond that, that is an injury and it's a usurpation. It's also something that is listed in the Declaration of Independence. The word consent is in there a few times. For example, governments are instituted among men, deriving their just powers from the consent of the governed. And that list of grievances, he has kept among us in times of peace, standing armies without the consent of our legislatures. This is also kind of an early 10th Amendment type of delegated and reserved powers approach, because if the local legislature has to give consent, or it's an injury or usurpation of power, that means there is a line in the sand on what even the British Parliament was authorized to do, according to the revolutionaries. And also for imposing taxes on us, without our consent. We'll get to that again in just a moment. So number 2 is about consent and consenting to only a certain amount of things that they're authorized to do. Number 3 is really that 10th Amendment argument about delegated and reserved powers, a line in the sand about what the general government is authorized to do, the federal government, and what is reserved to the states, respectively, or to the people. And he points out, again, the states are not united on a principle of unlimited submission, but he said that by compact under the style and title of a Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government. And when you're talking about the people of the several states, again, this is about they consented to the Constitution at that time, and they all delegated a certain amount of power, and everything else is not with their consent. And there is a clean line in the sand. Now, during the Revolution, that radical change in the viewpoints of the people from 1760 through 1775, there were a number of situations where this notion of really kind of like delegated reserved powers, a precursor to the 10th Amendment and the constitutional structure, had really come up as very important. For example, the Stamp Act. If we're talking about imposing taxes without our consent, the Stamp Act is probably the greatest example of that. And Patrick Henry, who may be the original 10th Amendment guy in 1765, really made the case in his Virginia Resolves against the Stamp Act that Parliament could only do certain things. Other things, like internal taxation, were reserved to, well, the states or to the people. We'll put it that way. And here from those Virginia Resolves in 1765. Resolved, therefore, that the General Assembly of this colony have the only and exclusive right and power to lay taxes and impositions upon the inhabitants of this colony. Now, of course, we're not debating or discussing whether or not such a taxing scheme would have been good or bad done by the General Assembly of Virginia, and neither is Patrick Henry. He's basically just taking the position that this is not even something you're authorized to do. And because of that, he had an additional resolution that said, resolved that His Majesty's liege people, the inhabitants of this colony, are not bound to yield obedience to any law or ordinance whatsoever designed to impose any taxation whatsoever upon them other than the laws and ordinances of the General Assembly aforesaid. So Patrick Henry, again, this is a very important principle of the American Revolution that really lit a brush fire in response to the Stamp Act, because this is May of 1765. I believe it was May 29th. I'm just trying to think of it. Yeah, May 29th, 1765. And that really got the word out. The idea that they're not authorized to do this. So if they're not authorized to do this, it's illegal, and no one needs to follow an illegal act. So number 3 is about delegated and reserved powers. And some years later, well, before the Kentucky resolutions were passed, 1791, in Jefferson's opinion against the constitutionality of a national bank, he points out that this principle is the foundation of the entire Constitution. It's the structure of the entire thing. And he put it this way: I consider the foundation of the Constitution as laid on this ground, that all powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states or to the people. Or John Jay, the first Chief Justice of the United States, described it like this: the Constitution only serves to point out that part of the people's business which they think proper by it to refer to the management of the persons therein designated. So government isn't supreme. The Constitution is supreme, but only supreme as far as what the people have determined that they want to put in there. The people of the several states delegated certain powers, and that is number 3. Now, on top of it, back to the Kentucky resolutions, Jefferson is pointing out that allowing an exercise of undelegated power is basically the same thing as giving them unlimited power. So if they can do things that they're not authorized to do, what's the difference between that and saying that they have power over the states, the people of the states, in all cases whatsoever? And here's how he put it: this Commonwealth is determined, as it doubts not its co-states are, tamely to submit to undelegated and consequently unlimited powers in no man or body of men on earth. So if it's undelegated power, it's consequently unlimited power. So point number 3, or essential principle number 3, is about delegated and reserved powers. Now, number 4 is that the Constitution is supreme, not the government. The government doesn't get to determine the limits of itself. It is the created, the people of the several states created via the Constitution, the general government. So the general government doesn't get to determine the limits of its own power because, again, that would give them unlimited power. And this is how Jefferson described it. The government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its powers. So for Thomas Jefferson, the people of the several states created a constitution. They created a set of limited delegated powers that the general government was authorized to exercise. And it wasn't up to that government to determine whether or not it was going beyond the limits of its own powers. He said, but that, as in all other cases of compact among parties having no common judge, each party has an equal right to judge for itself, as well of infractions as of the mode and measure of redress. So each party to the compact, and the parties to the compact, as James Madison also described in his report of 1800 about the Virginia resolutions of 1798, that the parties to the compact are the people of the several states. So ultimately, the sovereignty, final authority is with the people of the several states, and each state, the people, can make their own determination of whether or not they view something as constitutional or not. Maybe it's just expressing opinion, but if they have that opinion, it is also up to them to determine how they want to deal with it, the mode and measure of redress. So number 4 is constitutional supremacy, not federal supremacy. And number 5, we're just going to use one word, void. And here's Jefferson's take. Whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. If the government, by exercising powers not delegated to it, is consequently exercising, in essence, setting the foundation for unlimited power, then automatically, in principle and in theory, any power that's not authorized to them, not delegated to them, is void. That's the same principle that Patrick Henry took in response to the Stamp Act, because if it's void, and even Alexander Hamilton in Federalist 33 talking about federal supremacy, and this is my paraphrase, he said those acts that are not supreme are usurpations of power and deserve to be treated as such. So if you're treating something that is void, a usurpation of power as such, it's as if it doesn't exist. So it has no force in law. And this is very similar to what James Otis Jr. Now, John Adams referred to James Otis Jr.'s speech against the writs of assistance in 1761 as the beginning of the controversy between the colonies and Great Britain. And this is James Otis, many things that he said in that long speech, but he said an act against the Constitution is void, because if they're not authorized to do it, it is not law, and therefore no one is bound to obey it. Roger Sherman, in December of 1787, describing the structure of the Constitution in a very similar way, he said, all acts of the Congress not warranted by the Constitution would be void, nor could they be enforced contrary to the sense of a majority of the states. And that brings me to my bonus point, number 6. The rightful remedy. And for those of you who follow our work here at the TAC for any amount of time, you know where this is going. Jefferson is talking about, well, how do you deal with a federal government doing things that either you don't like or that you think are unconstitutional? He said, this is from his original draft, which was somewhere around or a little bit before October 4th, 1798. He said, in cases of an abuse of the delegated powers, the members of the general government being chosen by the people, a change by the people would be the constitutional remedy. So if you don't like how they're using the powers delegated to them, the vote the bums out strategy is what Jefferson is recommending. But, he's continued, where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. So anytime they're exercising power that is not delegated to them, this is a usurpation of power. It is unauthoritative, void, and of no force, as Jefferson told us earlier in the document. And how do you make it that way in practice? A nullification of the act is the rightful remedy. Not just a good idea, not something to try way down the line, not something to try in 6 years or 8 years or 4 years. It's the rightful remedy as soon as they do it. And he said that every state has a natural right, in cases not within the compact, to nullify of their own authority all assumptions of power by others within their limits. That without this right, they would be under the dominion, absolute and unlimited, of whosoever might exercise this right of judgment for them. Again, getting to unlimited power. Well, I hope you guys found this interesting. I hope it was educational. More important than anything, I hope you learned something. There is absolutely nothing that helps us get this kind of information out to more and more people every single day, more than the financial faith and support of our members. Our membership program starts out at just $2 a month over at 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. I would be very grateful for any consideration you can give to joining us today. Again, it's 10thamendmentcenter.com/members. Again, I really appreciate you spending some of your time with me today. I hope you enjoyed the episode. I hope you have an awesome weekend, and I hope to see you next week here on the Path to Liberty.